Okay, thank you.
Put it back on?
But I'm still off camera, Ryan, right? Am I on or off?
You got just this.
Always on.
Just your flipper.
No, that's on, which
It's
is,
good to have that attitude.
oh, trust me, I know.
Alex, now you're on.
I have children,
yeah,
I have children who are actors, I know
can't
what
move my
that
head
is.
too much. I'm like everybody else.
I'll save that story.
I don't think I can sit here.
Once important. Okay, so one of the things that I stalled out at the end of a page, and I want to make sure to get this point in here, because this is kind of important. And that is, remember the first thing we went through was that contract. That contract had a lot of stuff in it. The contract is, I think I started off that day saying that it's like the constitution of the real estate transaction. But when do you think the real estate transaction ends?
Effective date?
When the person that bought the property sells it to someone else.
No. That would be, when do you think the real estate transaction comes to a conclusion?
Possession?
More formal. I need something more formal than that.
Effective
The
date.
keys, like the dirt, like you said, like.
All components of this thing. We
Close
know what
it.
the word is, what this event that takes place? Come on, realtors.
Closing?
There we go. Come on. We have a closing. And at the time of the closing, the documents get delivered, the deed gets delivered, the money changes hands, and then everything gets sent off to recording, and title insurance gets issued, and we're going to go into title in just a second. But what happens, the reason I'm going through this little exercise, is that the contract merges into the deed. This is a very important concept. All the promises, all the representations, everything that you see in a standard form of contract, it merges into the deed. It becomes part of the deed takes over, the closing happens, and the contract goes away. Except when we're dealing with certain covenants, and you won't find it in the form contract, but you'll find it in the larger deals, the custom contracts. There are going to be specific things that are going to expressly have a sentence in there, this paragraph survives the deed. And the reason for that is there are certain representations and warranties in a commercial transaction, like the covenants that we haven't done anything environmentally bad, which we saw that in the fascinating loan documents, that there was a particular document for the bank that said that. But in a commercial contract, you're going to have a provision that says that we haven't done anything to the property, we haven't had any environmental violations. So that would normally expressly be made to survive the closing. Everything else that doesn't expressly survive merges into the deed and goes away. So now, what happens to the deed? The deed gets sent for recording. Why is it sent for recording? Well, because we don't want to keep it a secret. The thing on the screen says it's intended to protect title by preventing fraud. That doesn't do very well. But more importantly, it does establish the priority of rights. Remember what I said last week when we were talking about recording the mortgages? First in time, first in right. Whoever gets there first. However, there are different kinds of recording statutes around the country. One is purely a race statute. Whoever gets there first wins, period, doesn't matter. Florida has what's called a race notice statute. Yes, whoever gets there first, except if somebody knows something. So somebody raised the question of the bona fide purchaser. A bona fide purchaser is someone who, for value, acquires the property with no knowledge of anything bad. If I am getting a deed, and I know, because I was in the room or something, that you ran to the bank first and recorded a mortgage yesterday, even though it's not recorded when I get that deed, I have the knowledge. And there's two types of knowledge, three types of knowledge. There's actual knowledge. I'm actually in the room, I'm actually hearing, I see what's going on. There's constructive knowledge. Constructive knowledge could mean that it's in the public records already, it's recorded. Something in the public records gives constructive knowledge. You are presumed to know what's in the public records. Could be constructive knowledge of somebody else having an interest when you go to do the walkthrough of the house and there's somebody sleeping in the back bedroom. That might tell you something. And then there's inquiry notice. Inquiry notice is something that you discover that should legally tell you to go do some more digging. The person sleeping in the back bedroom is a good example. You walk in to do the walkthrough of the house, and maybe you see a path, a footpath down the side yard that looks like somebody's been walking through the grass. That might look at you and go, wait a minute, is there an easement there? Does somebody have some rights to go across my land? So that would put you on inquiry to go do something, check it out a little better.
How would they ever prove that?
Prove what?
That you had that knowledge?
You went for a walkthrough, right?
Right.
There was a path there. You could see it. You couldn't get to the front door without walking by that path. Enough? Okay. So documents are recorded. The documents are recorded to establish the legal right of record, to establish the priorities. That. Okay. Title. Marketable title. What is marketable title? Marketable title is a quality of title that lets you be in the property free of encumbrances, free of liens, free of things, or as it says right here, free from reasonable doubt that the seller owns the title. Marketable title standards are established from state to state as to what can affect marketability and what can't. If something renders the title unmarketable, let's say that there's a condition, let's say that there is a reservation that is discovered in searching the title that would allow someone to come in and dig for oil, or would allow someone to use the property adverse to your use, or you find that there's an old lien on the property. There's all kinds of clouds on the title that can occur. It could be a construction lien. It could be an open permit. Now that's really something a little fuzzy. But I'm going to, since I'm talking about clouds, I want to talk about this just for a minute. There's a major problem in real estate transactions these days with permits. I'm talking about permits to do things on the property. You want to go put a new roof on your house, you got to go to the city and get a permit. You want to do electrical work in the house, you're supposed to go and get a permit. You want to add an addition to the house, you're supposed to get a permit. And the way the process is supposed to work is, as you go through the construction process, you are supposed to call out an inspector at each step of the way and have them make sure that the electrical wires are put in properly before you put your drywall up. And they sign off. And when the whole process is finished, a final inspection is made, and they sign off a final inspection, and then the permit gets closed. What winds up happening a lot is not so much on a large construction project where people are paying attention, but the situation where you're going to have your air conditioner replaced in your house, and your contractor goes out and does the right thing and gets a permit because they're hooking up electrical stuff and they have to have a slab and so on. And then you pay them and they leave, and they don't bother to call the final inspector, you don't bother to call the final inspector because the air conditioning is working just fine and you're not paying any attention. 3 years later, you go to sell the house, and you know it's great because you can tell that people don't have to spend the $3,000 because you replaced the air conditioner just a couple of years ago, and it's got a 10-year warranty. And when the title company goes to do their closing, they do a lien search to see what's in the public records and what the city says, and they also do a permit search, and they find that this permit has never been closed. So all of a sudden, red flags pop up, and people stop and they go, well, wait a minute, you got to close these permits. Why? Well, if the permit isn't taken care of while you have the seller in front of you, and you go down the road and somebody else objects to it, they may find that the wrong type of wire was used. Something wasn't done. Question?
No.
Stretch. Okay. The wrong type of wire was used. Something wasn't done properly, so the inspection was never finally done because it wasn't done correctly. And now, if you're down 2 or 3 owners down the road, the next person that goes to do something may get stuck closing that permit and doing whatever corrective work. I had one situation, it was this as bad as condominium unit. They had replaced the shower, but they never had the final inspection done to see that the pipes were done in the right place. When the open permit was discovered, they had to call out an inspector and a contractor and reopen the wall in the shower so that the inspector could make sure that the plumbing was done correctly and then close the wall back up. So this is a problem. The problem gets worse when you're doing a current closing and the open permit is from the 1990s. Because, you know, they don't go away. I'm actually working on a Florida Bar task force to try and deal with this and change the law a little bit and do things like allow a current contractor to come out and correct the issue and get the permit closed so you don't have to go and find the original contractor that pulled the permit? Question.
Do you foresee, because everybody's starting to go to the e-permit system, do you foresee like a bunch of properties starting to pop up with unclosed permits, or are they just going to kind of like turn their eye?
Well, part of the problem with going to the e-permitting system, which is, you know, everything works better. It's like everything's better when it sits on a rinse. It's all better with the electronic stuff, the electronic recording, things like this. It all makes things better. But it doesn't fix what happened before. And they're not going to go back. Because I've met with officials in a couple of different cities, they want this to go away. They don't even know what's in their files before they went to the electronic systems, before it went to computers. Because, you know, there used to be a punch card or something, you know, a little fill out the cards. I'm working on a situation right now where property was built in 1959. It was properly permitted as 7 units. They have a county, whatever, for 7, it's on the property appraiser's office for 7 units. But the city says, no, it's only supposed to be 5 units. And it's been 7 units since the late 50s, and the client can't get the business tax license, used to be called an occupational license, so that they've gotten a code violation for not having the license. They can't get the license because they have too many units. So we're trying to uncover and figure and go back into ancient history. So these are things that have to be checked out when you're closing. And unfortunately, by definition, when you're looking at marketable title, sorry to go off on a tangent, but coming back to the marketable title, the permits is not something that's deemed a title defect. It's actually now by contract, you'll see in most of the real estate contracts are going to require the seller to deal with the open permits, and title companies are going to object on behalf of a buyer, but it's technically not a defect because it doesn't become a title problem until the city issues a notice of violation and fines you. Then it becomes then they'll file a lien, because if there's a code violation on the property, the city can actually put a lien on the property, and in some cases they can say, if it's bad enough, this is another major problem you see in title, another cloud on title, they can say that if you don't fix whatever it is, we're going to fine you $100 a day until it's fixed. And it gets ignored, and all of a sudden you're looking at huge amounts of money.
So what about, how would this apply, like, let's say it was like unincorporated in an unincorporated part of the county, and then it was annexed or whatever into a municipality? How do they do it?
They check both.
Yeah.
They check both records, depending on how, yeah, no, I've had that situation out with the stormwater drainage system. And we checked both, and I couldn't find anything in the city until I found out that when the property was built, it wasn't in the city yet. And then we still found out that there was no permit for stormwater drainage, which basically on your commercial property, you have to do something, you have to have a provision on your property for the rainwater. And my client bought the property next door and tore down a building and was building a new improvement. And when they started working on the site work, they found a pipe. And the pipe just came from the other property and was coming through their property. And so they cut it off. They just closed it. We did research, we looked at all the records, there was no easement, there was no filed stormwater drainage, so we closed it. Well, you should have heard the screaming from the people next door when the parking lot backed up the next time. Because now the county and the city require you to deal with your own stormwater unless you have a legal right, an easement, another kind of easement, could be a drainage easement, to use your neighbor's property to get your water off site. It's, you know, it rains, you see, it's raining today. Where does the water go? Gotta have a place to go. Well, you dig a ditch, and that's where the water goes. and then all of a sudden the property around the ditch is waterfront, you can charge more for it. True. Funny perhaps, but true. Okay. Okay. Near and dear to my heart, and of course, you guys know I like props, so let's see if we can get this one to work. How do we find out the state of title? Those of you that work in real estate know, oh, you go to the title company and they call and they get you a title commitment. And I'm going to show you what a title commitment is and what it does and all kinds of things like that. But first, I'm going to show you how it used to be done. This is when I started practicing. Now, you could do it, but we all did it ourselves. What I'm holding in my hand is called an abstract of title. You can tell because it says so big letters across the front. I don't know if this is going to work, but I'm going to give it a try. What's that? Fragile? Oh no, it's the size of a phone book. Anybody know what a phone book is? Are we getting any light over there? I'm working on it.
If it's not working, you press and hold.
Let there be light? No? Come on.
There's something.
Anything blink?
Yeah.
There we go. It's warming up.
Okay. Is there supposed to be a screen?
Right behind you.
Yeah.
That's black.
Aha, thank you. See, when I was a young whippersnapper, you had to take a Hulk.
It worked.
Okay, abstract of title, it says so right on the cover. Okay? And this book, the size of a phone book, again, half joking when I say, does anybody know what a phone book is? This is actually the history of a piece of property. And it contains copies of every document. Yeah?
One parcel?
Yes, that's a house lot. That was my 2 houses ago when I lived in Emerald Hills, yes. Because we stopped using these, and this is small. This is only 1 volume. We stopped using these because a couple of different reasons, but basically because everyone is using title insurance. It was cumbersome, it was a little old-fashioned, and honestly, the bigger firms weren't examining title for themselves, so they just started relying upon the underwriter because it's a liability issue. But when I was first trained, I mean, I was not locked in a room, but I read 8 to 10 of these a day, 6 days a week. Now, what happens is, every time the property changes hands, this gets continued. This is how it used to work. I mean, this is already stale because we're not using them anymore. So you'll see there's a different cover for each individual company. As it got continued, it just keeps adding on. Now, can we see the plat? Mm-hmm. The plat is multiple pages, but this is a plat of Emerald Hills. And so the first thing in Emerald Hills, not of Emerald Hills, this is actually Hollywood Hills North Section 1. And this is the first thing that is in there as a courtesy, so that you have it in a good size and you can look at it. And it's several pages. And what you'll often see is that an examiner, can we see down to where my finger is? Because I can't see what you see. Finger?
Yeah.
Okay, you see where I have that blue?
Yeah.
So that was the lot in question. So what happened was, just for ease, when you go through it, you go into the plat. Most people don't, but I mean, you take a marker or pencil, in this case was a blue pencil, and you mark that. And there was a slightly different, you see that?
Mm-hmm.
This was an older plat because that had been a replat, so this looked at an older one, it's the same piece of property. Again, prior subdivision of the properties. So this goes back to the large government subdivision when, I think I may have discussed section, township, and range, where it starts like there's a meridian that goes through Tallahassee, and the whole state is divided up into quadrants that way. So this was a depiction of that. This is Township 51 South, Range 42 East, but this goes back to I don't know when, because you can tell just the fact that it's handwritten. And this is a location note that just describes where it is in relation to the land. And, okay, now I want to get to this.
Bank of Arkansas.
Can we see the top of the page yet? No, good, I can.
It's all Arkansas side of it.
When you guys buzzed, we came down and.
Okay. See up here? I'd love to be able to see what you're seeing at the same time, but it's, okay. So what happens here is, when I said that this history of the title goes all the way back to the beginning, it goes all the way back to the beginning. And here is the treaty of 1819, with the treaty with Spain, where Spain actually gave Florida to the United States. And the next page, or the next instrument, talks about, it's the patent of the, can I zoom this out? Let's see. Better?
Yep.
Okay. Can you see down here? So this is actually an act of Congress by which the United States is transferring the property to Florida. And it literally goes through the ancient history of the land. Now, take a break from the document itself and talk about, bless you, talk about what happened. Okay, great. See up here too, right? Okay. There was a company called the Florida Coastline Canal and Transportation Company that in 1889 was given a contract by the state to create the Intracoastal Waterway. And their job, remember this was all swamp. It was, there was some highlands, but it was mostly swamp. And they were given the contract to dredge basically a canal using some natural rivers, but mostly not, down the eastern seaboard of the state of Florida, which was a way for boats to get down. And it even talks about, okay. It even talks about canals and waterways of the company shall be not less than 50 feet wide and not less than 5 feet deep at mean low water for the entire distance between St. Augustine and Biscayne Bay. Okay? That's
a nice contract.
well, of course, but think about it. This was the wild nothingness back then. So they did that, and then here is a deed from the Trustees of the Internal Improvement Fund, which is still in existence. This is an arm of the state of Florida, and they're deeding to this company straight? See all of these? Lots and lots of sections. Okay? So what they got, and this goes on for 2 pages, paragraphs of 2 pages. What they got as part of this was land alongside where the canal was being created. And then this is just, I mean, not terribly important, but this then talks about proves that the company existed, because in order to have a proper conveyance and proper title coming out of an entity or going into an entity, you have to know that the entity actually existed. Today you can go on computer and see the Secretary of State when it was formed, that it's in good standing and things like that. But back then, and up until computer time, we had to get a certificate from Tallahassee saying that it was formed on this date and is in good standing as of that day. And we recorded all of these things to prove that if title went into a corporation or came out of a corporation or any of the other artificial entities we were talking about, that it actually existed. If it didn't, there would be a cloud on the title and you'd have to do something about it. This is a deed of trust, which is another way of having a mortgage. They borrowed money to do this. Just to get an idea, in 1885, they were borrowing $400,000. Wow. So the next document you see is a release of a deed of trust. And what we had to do as title examiners is we had to go through all of these documents. And number one, we had to see that whoever received the property eventually conveyed it out. We had to make sure that if it was an entity, that the entity existed. We had to make sure if there was a mortgage, that there was a release of the mortgage, and that all these things were proper. So we went and we looked at all of these documents through this whole book, and if I tell you, I'm not exaggerating, that I did 8 or 10 of these a day. That's what I did when I first started practicing. This is how you went through all of these, the histories of all of these titles, and checked them to see what was going on. Now, there is a statute called the Marketable Record Title Act. Very important, because it says that if something is more than 30 years old, and there's a root of title, a chain of title, that is more than 30 years old, you don't have to go behind it. With very few exceptions, there are certain interests that it doesn't extinguish. But other than that, it gives you a starting point, so you don't have to go back to the 1800s like this. Okay, let me, and here's a deed. Here's a deed where they're conveying out all of these sections. Now, when you see on these legal descriptions, I just want to show you something. Can you see here, finger? Yes. You see where it says all of section 33? And then these paragraphs are all section this, section that? Each section is 640 acres. That's to give you an idea of the magnitude of this property that we're talking about. And all of these various sections, and each one, as you see through this section here, each numbered section is 640 acres. It's a substantial quantity of land. I won't use the word I was thinking of, but it's a lot. So, what happened later on was that this Florida Coastline Canal and Transportation Company, this is just some good history, they, through a couple of name changes and mergers and such, became known as your good friends of the Florida East Coast Railway. And so that's how the Florida East Coast Railway was originally created, and that's why they own all of that tract, all that railroad track that goes down the east side tracks over here where Brightline is running now. They actually own that, and they own obviously a lot more than that. But as a result, they could do whatever they want with that property. That's why they had so much control, and they always have to be dealt with. And then, so here, just as an example, you see a conveyance out of the Florida East Coast Railway Company, which is what they're called, or maybe the name is a little different now, to an individual, and it's conveying a piece of Section 5. And this is in here because if you went back to that very beginning page, it would tell you that by shrinking and shrinking and shrinking down, that this land was originally part of this piece of Section 5 before it was platted when it was still raw land. But what happened, jumping way ahead because you don't want each page to be discussed, I promise you that. You're getting the idea. Sorry. What's going on here is you're going through all the history up to a point in time. And it finally got into a company owned by a man by the name of Joseph Young. This particular one of this fact. Joseph Young, anybody from Hollywood? No? Joseph
Circle?
Young, you know, anybody know?
Oh, Young Circle.
Yeah, there we go. So
Oh,
Mr.
that's
Young,
why it's called like that.
Heat it up for him.
Mr. Young was the person who created Hollywood,
Come Uncle Joe.
and sometime in the 1920s, oh, here's a fun one. You like history? This page is in 1915, and it's the creation of Broward County. So they took a chunk out of Palm Beach County, a chunk out of Dade County, and they said, we're going to create a new county. And they called it Broward County, named after Napoleon Bonaparte Broward, who was the governor of the state of Florida, and his big accomplishment was that he drained the Everglades. He was the one that spearheaded the draining of the Everglades.
Oh, I thought that was Flagler that did that.
No, Flagler was the railroad.
Oh,
Flagler was actually the owner of probably the Florida East Coast
the
Railroad.
Melaleuca plant guy that put the Melaleuca plants and dropped the seeds in there? Well, that's what they did to
stink.
drain the swamp.
Sure, that is one of the things that they did, it's absolutely right. What Governor Broward did was, he created canals and ditches. And by doing that, you see them all over the place.
Yeah.
And by doing that, the water left the land and went into the canals and then flowed out to the ocean or whatever they did to keep it. And that's how we started to create more land. The Melaleuca trees are more used out west, the western part of the county. But the original, the creation of the canal system is how they trimmed the Everglades and made it more buildable land. So back to Mr. Young, I'm trying to get a little further forward here. It went through various people.
So when did they come up with the urban development boundary?
Oh, that's a development, that's a much more modern concept. Remember, I'm back in the 20s here. So, yes,
Was US one the same way? Because I noticed between, like, I would say Griffin and up to like Allendale, Pembroke, the whole US one is full of like little motels. Was it always the same way for the whole US one, or is just that specific?
well, if you go back in time, and I can't tell you exactly when, 20s, 30s, 40s, people came down and they traveled by car, and they came down US 1,
Oh,
and all of a sudden they arrived in paradise. And so they wanted a place to stay. And especially in places like Hollywood and Hallandale,
yeah.
they weren't super wealthy, and there weren't hotels on the beach like there are now. There were actually private homes on the beach.
Oh, okay. So there's
So that's why the hotels wound up, motels, where the
yeah,
cars are.
motels.
Motels, which is really, the word came about because it was a motor hotel, where you could drive your car, park in front of your room, or near your room, and that's how it became hotels, yes.
Eisenhower created the, what, I-95 or
The
the highway?
interstate system,
Interstate
yes.
system?
Yes,
What year was that?
mid-50s. And the interesting fact about the interstate system, people don't realize that 1 out of every 8 miles has to be straight so that you can land military aircraft. Okay, so I'm not going to sit here and flip all pages at you because it'll be almost as much fun as the loan documents. But what I
But
do
now
want to
it's
tell you about
unthinkable.
is
But
what happened with
I
Joseph
just
Young.
then when they were thinking about it.
Everything's our airboats, like we need it.
Mr. Young was developing the city of Hollywood, and he was selling. Here we go. He was selling Home Seekers Realty. That was the name of the company. He was selling lots to people from up north who would come down and buy lots to build houses, and some of them were little 50-foot lots, some of them were bigger. And he entered into a contract with a company from Ohio that paved the roads. If you're going to build a new city, you have to have roads, right? So they started building the roads, and along came the terrible hurricane in 1926, and wiped everything out, and all the people that had investments lost their money. People couldn't afford to build houses. The houses were destroyed, buildings were destroyed, people stopped coming, the access was destroyed, so he couldn't pay for the road. So
there was no entrances at the
the
time?
company that built the roads filed a claim of lien, a construction lien. And of course, since Mr. Young's business got wiped out, he couldn't pay them. So what happened was, the Ohio Paving Company foreclosed their construction lien. And, hang on, I'm sure it's in here. The Ohio Paving Company foreclosed its construction lien and basically acquired approximately now from Pembroke Road to Sterling Road, from Dixie Highway up to 441, roughly.
That's quite a lot.
Okay? I mean, with a few exceptions. So imagine that swath of land that they acquired in the 20s because that's what Young's company owned and that's what he lost to this foreclosure. That company then morphed through various transactions, so those of you that may have been involved in real estate or know any of the history, to a company called Hollywood Inc. Hollywood Inc. was one of 3 companies owned by a family. They owned this paving company, they owned a newspaper in Cleveland, and they owned this real estate company in South Florida that built, if you spend any time in any of the areas around where I described, they built several of the malls, they built office buildings, they built apartments, and they sold off, and they built a little neighborhood called Emerald Hills. They also built Hollywood Hills. Because of this foreclosure and what went on there, the average cost of a lot to them when they sold it, when they developed Emerald Hills, was 17 cents. Because it was just it was so much land. Oh, here's the sheriff's deed. Oh, they shaved it down, unfortunately. This sheriff's deed from 1930. So and I will talk when we talk about defaults and things in a later week. At the end of the foreclosure process, the property gets sold at public auction. That's how you get your money back. How the bank gets their money back, or in this case, a construction claimant gets their money back. You go and you sell the collateral at public auction. The money comes in if there's a third-party bidder and pays down the debt. Or they get the property in satisfaction of the debt. Remember I said, if you don't pay your mortgage, they take your property back. That's how it works. So and I'll go through the mortgage foreclosure process and what it does in great detail. But here, this is the very end of the process. And at the end of the process, the sheriff deeded to the Highway Construction Company of Ohio all of the land I just described. However, in this instrument, because they were trying to save trees, it's just the legal, see this here? It's just the legal description of this one lot.
So why did you choose this specific one?
Abstract?
Yes.
It's my house. It was my house 2 houses ago. And what happened was, when I bought the house, we were still using abstracts, and we examined the abstract to issue the title. And by the time we sold the house, people stopped using abstracts, so I had nobody to give it to. So I kept it. I actually keep it, because it's a thing of antiquity, I keep it for display purposes.
So then the abstract's private property?
Yeah. This is not what's in the public records. Oh, see, I'm not going to do this to you, but all the lots are in here. All the magnitude, and you'd never see it from the paper, but all the magnitude of that foreclosure. Okay, so what happens is, so now you go through examining the title, you've got besides lots of history, then you get things like the Declaration of Restrictions. So the Declaration of Restrictions, and this would come under the category that I talked about. Actually, you can see some of this? I gotta be careful because now there's so much bulk at the top, it's gonna fall over. So this would be under the category of matters common to the subdivision. This would be one of the things that would be a valid subject to in a deed, because it is a reduction of the warranties of title, because you can't warrant against this. This affects every property in this whole subdivision, and therefore it is a valid title exception. Okay, enough of this. Let's move forward in time.
So the state did not maintain copies of those?
Yes. No, wait, this is a compilation of what's in the public records.
Okay, and that's why it's called an abstract.
Okay. I'm not so sure that's correct.
I'm just trying to figure out what would the state call it?
It's not a state creature. It's a private creature. It's an abstract of title. It is a privately created synopsis. And let me go back a second and see if I can show you. No. Hang on 1 second. So when documents get recorded in the public records, documents get recorded in the public records, and the public records get searched. They can be searched in 2 different ways. They can be searched by name, what's called a grantor-grantee index. If you go onto a computer and you look at the website for the clerk of the circuit court, you will see that you can see that if you put your name in, for example, if you own a house, you'll see under your name that it'll show everything related to your name. So you can go see that if you bought something, you'll look at the deed, and you see the deed came from Mr. Jones, and then you go look under Mr. Jones' name until you find the deed to that same piece of property. That's very cumbersome, especially if you have an active investor in real estate, because they're going to have a lot of things, there's going to be a lot of entries. So what the abstracting companies maintain is called a tract index. They take their documents and they look at the legal descriptions, and they, which is basically how this is compiled, is that they take the legal description for lot 10, block 64, and they look at every document that affects that lot, and they put it into an index, so that they know only the things that affect that legal description. We don't have the capability to do that because it's a completely different way of indexing it than what's in the public records, and the way they search every day for transactions, that's how they come up with it, and that's why we rely upon either an abstracting company to do this, or now it's been replaced by a title insurance company who does the same thing, but without delivering this book for me to read. So what they do is they've established from time to time what is in the public records with respect to this property, and they go forward from the last time they issued title insurance. Now, you hear me using another word again. Here I go again, using words. What am I talking about with title insurance? Well, let me show you. Let's make this go away nicely. You need this to me again. Sorry, guys. I didn't realize it did that. All right, we're going to leave that there. So we don't need, and I will do my best to upload these documents for your insomnia. I'm going to try. Again, I tried to just send the PowerPoint around and do it separately. I'm not sure that it'll let me do it, but I'm going to make an effort. Now, did you all see the loan documents? Do they all show up?
Yeah.
Okay, good. So I am making a little bit of progress. All right, bear with me 1 second while I go through this silliness again, because I want to show you what title insurance is all about. Title insurance is an insurance contract. Title insurance, unlike a casualty contract, is a contract that ensures what happens as of a particular point in time. Okay. What I'm going to show you here, wait a second, make something else go away. Done this now. So, This is the jacket for a title insurance commitment. Title insurance is, this is a binder. You would call this a binder in regular insurance. The difference between title insurance and the kind of and casualty insurance that you would buy for your house or your car is your casualty insurance protects you against something that might happen in the future. So you're buying it today so that you will get money back to fix something or to protect you if something should happen in the future. Title insurance is a snapshot as of a particular date called the effective date, and I'm going to show that to you on the commitment. And that says that as of that date, your title is in this condition, and you have this quality of title, You own it, you have no encumbrances, and I'm going to show you the exceptions. So it consists of a couple of different parts. What I'm showing you right here is the jacket. The jacket's the same on every commitment but for the name, and it talks about what they're going to do, and it says that this part where it says commitment to issue is important because it says, subject to the requirements, we will ensure the title subject to the exceptions. Which means, in order to get the policy issued as they say, you must satisfy the requirements, and I'll go over requirements with you in detail, and we're not going to give you anything better than what's in here because we're not going to insure certain things. Okay? This is just a jacket which has the fine print, basically. All the definitions. It's an insurance policy. As you can see, it's all the stuff that you would see in any other kind of insurance policy, which basically means it's incomprehensible.
So you said jacket, binder.
Same thing. The binder commitment, it's called a commitment is the correct word. They're committing to issue a policy subject to certain conditions. Okay?
Okay.
Now,
And then they reference, you say that's the short one?
that's the jacket. That's the standard terms and conditions. Okay? We're now going to try and see the insides. I'd like to get this to go away and make that full screen, but I'm not getting anywhere. All right, is this relatively legible?
Yep.
Okay. So this is the guts. This is where each, just like the contract we talked about, each part of it has its own meaning. So you're going to see the commitment date. Commitment date is also referred to, well, the commitment date is the date that they have examined the title evidence to. It's as of that date, what you're about to see is what's going on here. In the policy, and I don't have a policy to show, but it'll do the same thing. What the policy will show the effective date. And the effective date of title insurance should be the date and time of recording of the documents being insured, which would be your deed and your mortgage, or deed or your mortgage. Because there's two different types, basic types of title policies. One is an owner's policy, which insures the owner, the person buying the property, as we're going to see with the interest here. And the other one is called a mortgagee policy, or a loan policy, which insures the lender. They are insuring different interests. One is insuring the fee simple title for the owner, and the other is ensuring that they have a valid first mortgage, assuming it's a first mortgage, for the bank. They are two separate coverages. They're purchased separately, although the underwriters give a break. If you buy them together, then there's only a very small add-on for the mortgagee policy because the way they're looking at it, the risk is basically the same. It's all happening at the same time. Nothing has happened to the title in between. So it's called the simultaneous issue rate, which is $25 unless the mortgage is greater than the amount of the purchase price, which only would happen in construction. So, yes?
So at a conceptual level, is this kind of insurance gov, private?
Everything we're talking about is private,
Okay.
okay? I don't know what country you come from where things are done by the government, but these are all contractual things, insurance,
And the capitalism.
abstracts, they don't
capitalism
control us.
system, everything is being
Maybe in Arkansas, but not here.
Well, you guys think this
Okay.
is not
So, I only say that to you because you have a theme. And I want you to understand this is all private. The only thing that's part of the government is the zoning regulations, and the recording office is maintained by the clerk. It doesn't govern anything but we charge a fee, and we record it, and we show you, and you have to figure out what it says, okay? Other than that, it's all private. Contracts, the deed is a contract between grantor and grantee. The title insurance is a contract between the insured and the insurer, all private, okay?
So is the owner responsible for, who's responsible for maintaining the records?
What records?
Like all these titles?
Well, it's not a question of responsible. They're there. It gets recorded. the responsibility would be the equivalent of this to say, you know, what's happened to it, who's done it. If you're the owner of the property, your responsibility is not to mess up your title. Don't convey it, you know, don't do things to your title. Okay? If you don't do anything to your title, then nothing's going to change in the public record, so nothing's going to change in this or in that. Okay? It's all your property. The same way you would say, I would say to you, if you don't plant the tree, then you're not going to have something obstructing your driveway. Same idea.
Okay, so just a quick question, so if I'm an investor and I'm looking to purchase a property, right? And I go to public records and I just try to pull all the public documents I can possible on this piece of property, right?
How are you going to know?
That's my question to you. Is it better for me just to pay someone a couple of $100 or $100 and they do?
You can't do what you're suggesting, and here's why. Remember I said what's in the public records is maintained by a grantor-grantee index.
Yeah.
You'd have to know who every owner was, and you'd have to search every prior owner's name.
I see what you're saying.
Okay?
Yeah.
They maintain it by the land, by a tract index.
Oh, that the private maintains it by the tract.
Tract, correct.
So the public doesn't do that at all?
No.
No, they just do.
Not in our system here in Florida. The only time you're going to find it done by the government is in a Torrance system where it's registered, and we don't have that here, where it's registered with the state, and you get a certificate, and the state, whatever the registrar of the Torrance register will give you a certificate. Just like getting a new car title, if you go to transfer your car, you're going to get a certificate. If you've got a lien, it's going to say so. Okay? That it works in a very similar way, and it eliminates all this.
So here's my confusion. So then a mortgage is filed with the state.
Correct. It's recorded. It's not filed. I mean, it's not filed with the state. It's recorded in the county public records to show, for the purpose of giving everybody notice that there's a mortgage on that property. That's the constructive notice I was talking about. That's the only reason it's recorded. And by the way, the failure to record an instrument, which is an important one, failure to record an instrument doesn't affect its validity between the parties. It just opens it up to not protecting its priority. I see a look of puzzlement.
So no, I'm trying to wrap my head around that. So
Okay, so if I give you a mortgage,
yeah.
if I sign a note mortgage to you,
Yep.
right?
Yep.
You and I have a contract.
Yep.
I owe you money.
Mhm.
My contract says that if I don't pay you, what do?
I'm going to foreclose. You're in
Okay.
default of
Correct.
the contract.
So we're in good shape here. We have this agreement between us. Now, by you recording the mortgage in the public records, you make sure that I don't go and give him a mortgage as well, another contract, and he gets it ahead of you, because whoever gets recorded first has priority against me.
Gotcha.
Okay?
Okay.
And by recording in the public records, you are giving constructive notice to the world, and we're all supposed to know what's in the public records. It's legal fiction. That's why you have somebody look at it for you. You have constructive notice that that instrument is of record.
And it doesn't matter that the date on my contract with you is before the date of your
Only
contract
matters
with
if he
him.
knows about it. That's the
He knew.
race notice concept. The date doesn't matter. It's whoever gets to the public records first, unless he knows about it.
Got it.
And then I would have to prove that he knew about it in order.
Right. How would he know?
Okay, I got it. Okay, I got it.
Okay?
Thank you.
And in fact, I mean, because now I'm the bad guy here, remember, because I just signed with you and then I signed with him. But I guarantee you, if you look, unless you want to go back and look at the loan documents somewhere, there's a provision in there that says that there's no other encumbrances. There's a representation, a warranty by the owner of the property to any lender that says, I don't have anything ahead of you.
Yeah, I remember that.
Okay? So I would be lying when I gave that to him.
Which would make you automatically in default to him because you're
I'm
misrepresenting.
breaching my warranty to him, so yes, I'm automatically in default. I'm probably breaching a warranty to you that says I won't put a second mortgage on the property. But as between the two of you, on your recording priority, if he doesn't know about you when he gets there first, he's in first position.
Okay.
Race notice. That's what we are in Florida.
Okay.
Okay? That's an important concept.
Thank you.
All right, so what we're talking about here now is, once we get past this, and now we've hired somebody to do this because we can't do it ourselves. So not only do we hire somebody to do this, but we're gonna get an insurance policy. Why? If we have somebody examine the title, and there used to be a time when we would examine the titles, and I would issue an opinion of title to somebody and say, I've examined your abstract, and you have 2 mortgages, and these restrictions, and that's fine. And we used to close bank loans that way, and not issue title insurance. So why, and title insurance is not cheap, it's thousands of dollars. So why might you say, why do you need title insurance? What good is it? Well, I happen to have a handy list. It protects against a bunch of different things. It protects against errors in the public records. Okay, we're relying on what's in the public records, but maybe something didn't get put in right. Maybe the clerk had a cold and put it in the wrong pile and it never got stamped in. There might be unknown liens that somebody didn't find. They didn't show up for one reason or another. You don't know. There could be illegal or wild deeds in the chain. You know, we talked about the quitclaim deed. There are bad people that can sign deeds to property that aren't theirs. But if you get title insurance, the insurance will protect you as of the date of your recording of your deed. That's important. I'm going to come back to that in a second. It'll protect you, and it'll say that whatever's there, we're insuring your title. There could be missing heirs. There could be an estate or a trust, and maybe they didn't find everybody that had an interest. Maybe there was a probate without a will, and we thought we got all the heirs. But we didn't know about the fling the guy had when he was in the Army, and there's a whole other family somewhere. All right? Trust me, it happens. Forgeries. Okay? The same bad guy with the, is going around there and he's signing somebody else's name to it. Undiscovered mortgages, liens, encumbrances, things that don't show up. All of these things are bad things that can happen to title that the insurance is going to cover. Unknown easements. An easement was granted, maybe it's an easement, maybe that week there was rain and the path that I talked about, the grass grew over the path so you didn't see it. But in reality, 3 weeks after you close, you find the guy that owns the land back there is walking through your side yard. And you say, hey, and he says, I've been walking through this side yard for 15 years. The guy that sold you the house gave you permission. So, unknown easement. Boundary or survey disputes. You need to get a survey. I haven't really touched on surveys, except to show you the one, that one building. But the survey discloses if there's encroachments and things. But your title insurance, if you have a proper survey, will cover that. Somebody dies and you don't know that there's a will. So you're dealing with heirs in an estate, and all of a sudden the will shows up and it's different after you've bought. So now, when you bought from one party, and in fact, the will left it to somebody else, and it turns out the will was valid. So your title's no good. Your title insurance will cover you. Here's a good one. False impersonation of a previous owner. I hate to use the example again, but you have Junior shows up at the closing and takes the Junior off. So, he says, shows identification. The closer's not going to know the difference, but you're covered by the title insurance. So let's look at the title. Let me talk about the commitment just a little bit, so you can see what the title insurance is, what it does, and some of the specifics. So here you see we have the commitment date. As I said, this is a snapshot, not a motion picture. It's as of this time and date, not what happens afterwards. If something happens to the title after you get your policy, you do something, somebody else does something to you, you can't go running back to them. It has to be something that happened at or prior to this time and date.
Okay, so it's including everything up to that point.
Prior to, not after. They are ensuring that as of the date of the title policy, the state of your title is as you're going to see here. So here, in 2A, we have the owner's proposed insured. Of course, obviously I've taken names out. And that says that the owner's policy is going to be issued in the amount of $800,000. The next in 2B, we said we're going to also issue a loan policy. This is a little unusual if it's the same amount. In this particular case, it's a family relationship, and father's loaning the son money to buy the piece of property, so if they make a profit on it, the tax goes to the son. Then in paragraph 3, section 3, this is very important. We've been talking about the quality of title, and here it recites what they're insuring is fee simple. Not a leasehold, not a life estate, fee simple. In paragraph 4, it says that as of the date of this commitment, who is title vested in? This is your seller. It's a good thing to see this because if you think you're buying it from these people and it turns out somebody else signed the contract, you have a problem. But this is pre-closing you get this. This is what tells you the state of the title. Then of course this gets signed by the agent, which is going to be either the title agency person or the lawyer. So now we're going to go into Schedule B, Section 1. These are the requirements, and it's very simple. I wish I could make this the whole page, but it doesn't want to cooperate with me. I need a tech person. All right. Is it okay? Is it legible enough, this stuff? So here it says the following requirements must be met. Number 1 says the proposed insured has to notify if there's somebody else that's there. And the reason for that is when we first issued, give a perfect example, when we first started this particular transaction, it was in the name of an individual. Because he went and signed the contract, and I'm going to buy this piece of property. And so the first version of this title commitment came with that person's name on it, which means they searched the public records to see if there was anything bad it recorded about his name, judgments and things like that.
If you wanted to make it bigger, upper left-hand corner download, and then it should open as a Word doc.
Do that or Control Plus.
And then just,
Click the bottom,
yeah,
click
click
this
the
arrow on the
bottom.
bottom.
Yeah.
Thank you. Thank you. Now the only thing I want to do is that. Okay. How's that? Much better, right? Better for all of us. Okay, so now we're going to get into B1. In B1, so in number 1, so here's what happened in this particular situation. The contract was entered into in the name of an individual. So they search his name to make sure that there's nothing bad in the public records that could interfere with the title. He then says, no, I want to take title in my LLC, which in this case we're calling Management LLC because I dropped the other names out. Now this number 1 says, if you change that, if you're going to change who it is, you have to give us notice, the requirements, so that we can check to make sure that this company exists and that there's no judgments or other claims against this company, so that when you acquire the title to the property title is good. Second requirement, pay the agreed amount, pay the purchase price. Well, if you don't pay the purchase price, there's nothing to insure. You don't own the property, there's no consideration. So that's a very simple requirement. Number 3, pay the premiums. Well, it's an insurance policy. If we're going to cover your insurance and your title, pay us what we're just like car insurance, house insurance. They're not giving it to you for free. Now we start to get into number 4. We talk about the documents that convey title to be authorized, executed, delivered, and recorded to public records. A deed and a mortgage. Okay? Then it goes on to say, as to the company, they want, number 1, proof that the LLC was in existence at the time it acquired title and it's currently in good standing. As I said, you need to know that an entity either acquiring title or giving a mortgage or getting a mortgage exists. If it doesn't, it's not good. Then in number 2, Romanet 2, it's asking for a review of the Articles of Organization and the operating agreement. Why? Well, the operating agreement or the articles might say that every member must consent to a conveyance of the property or a mortgage. If you just relied upon one person coming forward and saying, I'm the manager and I have authority and I can give you this document, you may be getting a false affidavit from somebody and the other owner shows, and this has happened, it's been the subject of a claim. The other person shows up and says, wait a minute, my document said he can't do this without my signature, and you should have looked at my operating agreement. So it's a requirement in order to insure the title. And number 3, it says an affidavit from the person executing the mortgage certifying all of these different things about the entity. That the entity is in good standing, who's allowed to do it, who manages it, who the identities of the people are, and that they're not in bankruptcy. And the last one is, because it happens in larger transactions, where the manager of the LLC may itself be an entity. So here it's requiring the same things for the manager entity to say that if that's also an entity, you have to verify that it's in good standing as well. Because just like we talked about legal capacity of a person not being able to sign, if the entity doesn't have legal capacity or the person signing on behalf of the entity, then it's not a good deed. And then it goes on to say if it's somebody else besides the person that has apparent authority or legal authority, then you've got to back up. Because sometimes the main manager of the company isn't going to be available for a closing, and so the LLC will appoint, or the corporation can appoint, another person as the authorized signer for a limited purpose, and there'll have to be a certificate to attach to make sure that we know that they have the authority. Number 5 is very important.
Intentionally deleted.
You're all asleep because it's almost 4 o'clock. It's okay. It's intentionally deleted. What happened was a requirement was satisfied. I think there was the original commitment came out, and there was a mortgage on the property, and the owner or the seller paid it off prior to closing. And you're going to see another requirement in here about just that. Item 6, they're calling for a lien search. They want to make sure things that are not recorded, that they're making sure that there's nothing there they're requiring us to go through that process. Same thing with 7, we have to check to make sure that there's no unpaid utilities. Number 8, places, now these are requirements that we as the agent for the underwriter, we're the ones issuing the policy, we have certain obligations. We have to update this 3 business days prior to closing. We have to get an update of this commitment just to make sure, because again, it's a snapshot. So what may have happened from the date of the very beginning of this document up until the closing date could be a month, or even if it's 2 weeks. So they want to make sure that that amount of time gets narrowed. And that amount of time has a name. It's called the gap, G-A-P, not where you get your G's. And I'm going to show you where that comes into play in Schedule B2. Item 9 says, get a survey. If you don't get a survey, there'll be survey exceptions. If you do get a survey, then the survey meets the requirements, then we can delete the survey exceptions. I'll show you what I mean by survey exceptions in a minute. Paragraph 10 it provides for what we call a seller's affidavit, which I had a copy to show you, but I'm not bouncing back and forth to show it to you. But it's an actual titled document that gets signed at the same time as the deed, by which the seller attests to all these various facts and others. And it talks about that they have the authority, that they're in possession, that no one's challenged their access, there's no violations, no taxes are due, no unpaid bills, no property owners associations, other pending things. J is important, that there have been no improvements, alterations, or repairs during the last 90 days, because otherwise it would give rise to a construction lien. If you don't do work to the property and don't pay for it, the person who did the work has the right to come and file a lien against your property. K, have I discussed FERC at all? The Foreign Investment and Real Property Tax Act?
Yeah.
15%.
Contract.
Yes, 15% would have to be withheld. Anyway, this K is part of the affidavit to recite that they're not a foreign person. L is a statement that says that the owner won't execute documents that can screw up the title during that gap period. M, no mortgage, that they have access, blah, blah. So that is basically the requirement for the owner's affidavit. Paragraph 12. So, because the seller said they went out and satisfied the mortgage, and we got a satisfaction of mortgage, the title company says, okay, we didn't see another mortgage being placed of record. All of a sudden you've satisfied the mortgage a few weeks before closing. We want proof that you paid them. We want to make sure that that satisfaction is a real satisfaction and that you didn't get creative with Photoshop. And it says right here, because the mortgage was recently satisfied. And then there it says at the end of this informational to tell you the taxes are paid for 2018. So those are all the things that you have to do in order to satisfy the requirements to insure the title. Big disclaimer at the top of Schedule B2, you'll see that they're saying that regardless of what the documents in the public records state, because what happens is you record something in the public records, it doesn't go away. And there's some pretty offensive stuff in the public records, believe it or not. Back in the 30s and 40s, there were restrictions that said that certain people couldn't own property in subdivisions. Now, I closed a transaction for a very good client of mine who happens to be Israeli. And in examining his title, there was a recorded restriction in part of East Fort Lauderdale that said that no one who was more than 1/4 Hebrew or Syrian blood could own this property. Now, obviously that's not enforceable anymore, as are any of the other kinds of restrictions. But it's still there. It's still a recorded document, and it's an exception in most titles. It doesn't have anything to do with this property, but I wanted to tell you about it because, so they have this disclaimer in capital letters here to make sure that, to say that even if we recite that that document is existing in the public records, because they don't sweep the public records and clear it out, we're telling you that even though we are accepting it from coverage, we're not republishing any of these offensive restrictions. They are not enforceable, but they're out there. And it just shows you what people did back then and got away with it. Okay, now, very, very important part of the title insurance contract is this next, is right above paragraph 1, and it says, the policy will not insure against loss or damage resulting from the terms and provisions of any lease or easement identified in Schedule A, and will include the following exceptions unless clear to the satisfaction of the company. These are exceptions from coverage. These are things they will not cover. So paragraph 1 is the gap, in fancy words. The gap is the period of time between the last evidence of title and the time you get your documents recorded. Usually when things are busy, they can only get their information within a couple of weeks of the closing. Now, with, again, the benefit of the computer indexing, I can reduce that a little bit by going into the public records and looking at the seller's name. Because now, even though we're using the tract index for the most part, you can use the grantor-grantee index, which the clerk publishes, to see whether the seller, whose name we know, in the last month has filed anything. So that helps. They're not going to insure against taxes and assessments for 2019. They're not due yet. It says so. Not yet due and payable. Remember I said to you last week that the taxes can come ahead of the mortgage if they're not paid. Here, they've done the research and they're telling you that the taxes were paid, but they're not going to insure against the current year's taxes. Now, if they're not yet due and payable, why are they putting this exception in there now, if it's a snapshot? The reason is that real estate taxes become a lien on the property as of January 1st of each year. That is actually when the assessment occurs by the county. That's the date that they determine the value of your property. Even though you don't get that notice until August as to the valuation, and even though the tax bill doesn't come out until November for the year in arrears, everything occurs as of January 1. So as of right now, the 2019 tax bill is a lien on everybody's property. Paragraph 3 are what we call the standard exceptions. We call them the standard exceptions. It says right there, standard exceptions. These are things that appear in every commitment and would appear in every policy unless you take certain steps to make them go away. In the requirements section, that thing that I was babbling about with the affidavit satisfies many of these things. A is the encroachment, and you'll see without going through the whole thing, it says, would be disclosed by an accurate and complete survey. If you get the surveyor is going to show if there are any encroachments. If you present the survey, you've proven there are no encroachments, this comes out. Rights or claims of parties in possession. You have an act in the affidavit, there's a statement, there's nobody in possession. Paragraph C, lien for materials. The affidavit says, haven't done any work in the last 90 days, that hasn't been paid for. Taxes or assessments not shown in the public records, same thing. Between the lien search that you take care of and the affidavit, you make the standard exceptions go away. Now, paragraph 4. They stick this paragraph 4 in almost every commitment or policy. If I showed you this particular piece of property, there isn't any water anywhere near it. But they've generated something in these things because they don't want to claim, and so they stick this in everywhere. If it's waterfront property, this would be an important thing, because where the things may have been filled in, which has happened all over the place, at one time it might have been navigable waters, and there is a technical claim. Typically, you want to make sure this, especially if you're doing development work, you want to make sure that this and any potential claims based upon navigability go away. I had one situation, I was practicing just for a couple of years, and my boss, who taught me how to read these at the time, made a practice. He was very frugal, but every year he took his family on an extended vacation, usually to Europe. So he examined title, and you said this looked big. This was to a piece of one of the condo projects in Turnberry, in Aventura. It was 15 of these for the property, okay? And so he examines the property and issues a 6-page letter of objections, ending with, I'm going to be out of town for 3 weeks. If you have any questions, call David. One of the things that he said was that it appeared that the condominium had been built upon submerged lands, which meant that somebody had taken dirt, fill, rock, whatever, and built a wall and filled it in because it made more land. So they could extend the building out further, whatever. This was really close to the intracoastal, is really close to the intracoastal. So this became a problem. They had to resolve it, whatever they did. I don't remember how they resolved it, but that's what this is about. That's what this exception is about. Number 5, the 159 exception is for utilities, because the government can have, the utility provider under the statute can have a lien on your property if you don't pay your water bill. And now we get into the specific exceptions. Again, we are in the page that says we will not insure against any of these things. So you have to read them. You have to look at them and you have to see what they are and what they say. I doubt very seriously this would work, but I want to show you. You see where it's blue? Let me just see something. No. So what they do, I'm going to give it a try. Yeah. You might get it. So what this is, the reason it's in blue, yeah, this is great. They've come ahead a little bit. So what I just did was I clicked the link. So here I am, I'm reading this commitment, and I'm looking at the commitment. By clicking the link, if it works, it's going to bring up a copy of the document, which is an exception. Maybe. Or maybe not.
It's Microsoft wasn't doing
It truly. No, I'm in Chrome, actually.
I think if
Now, when you click Control click, it goes to automatically the Internet Explorer.
Really?
Well, I don't know where it just went. It's gone now.
Yeah, that's
You
why.
probably need to click on
Said
the
not
browser.
responding.
Yeah, I saw that. It was close as up. I didn't see it.
So it looks like there's something already
Oh,
there.
then.
Yeah, it crashed real hard.
No, it would have popped another window.
If you right-click copy,
Don't worry about it. You don't, we don't need to see the.
stop copy.
It's funny as I look around the room, it seems that I see mostly little apples, but okay, that happens. Few purists. Anyway, this is a convenience that it's supposed to work, but this is, I've copied this over and moved this around, and it could also be a firewall situation with the university. So all of these things here are exceptions to title. They're restrictions, matters on the plat. Remember I said the plat could theoretically have restrictions on it that you can't do certain things. It's an industrial plat, so it might say you can't have houses. It might establish easements. It happens to be up next to a railroad. There's an exception for an ordinance. So when you're examining the title and you're looking at these things, you need to see what each of them does, and does it adversely affect the title of the property? Does it render the title unmarketable? Because even though you're going to get insurance, there's a difference between insurability and marketability. Because these are exceptions from the insurance. Yes, you can get the title can be insured, but it may not be marketable. If you have an existing use that says this property has a warehouse on it, that's okay. You don't have to worry so much. If you're doing development, you want to make sure that none of these things are going to prevent you from doing what you want to do. Like, for example, there's a driveway easement. The driveway easement is the equivalent of, in this case, there's like a stub street between two buildings. So the buildings are on a street and there's a railroad track behind them. The buildings are not related to each other, two separate owners. Building here, building here. They created an agreement with this driveway easement that said, since they each own to the middle of the road, to the stub street, they each are giving the other the right to use the whole road reciprocally so they can get to the sides of the property. So if you were trying to do something to develop or extend or change, and you didn't want your neighbor doing that, you'd have to deal with this. An educational mitigation agreement is usually a situation where you say, I'm building commercial property, I am not building residential property, therefore I don't have to pay impact fees for school creation. Well, when you build a new subdivision of houses, you have to contribute not only for the increases in road right-of-way, increases in water and sewer usage, and if you're going to put 40 houses there, you're going to have more kids going to the school system. So you pay all these impact fees at the time the plat is recorded. And then 10 is some kind of another easement that was modified. 11, in this case, it rights of tenants occupying. So unless you determine, you obviously should know who's in your building. But the title company is saying that until you resolve that and tell us that it's empty, we're going to put this exception in there because we don't know, we the title company don't know what their rights are. And as you'll see when we get into leases, sometimes you can give a tenant the right to stay there much longer than you think. You give them an option to extend the lease. Maybe you give them the right to buy. Maybe that tenant has what's called a right of first refusal, which says that if the landlord sells the property, I get the first right to buy it. So you need to know all of those things, and that they're saying, we, the title company, don't have the lease, we don't know what's there, we don't know what rights there are, you need to figure it out because we're not insuring over it. Then there's a few other, then it goes on to talk about under what circumstances they will delete those standard exceptions and delete the gap exception if you do certain things. And this, obviously I'm taking things out, this is the exhibit that describes the property that's the subject of this policy. So what happens now is this commitment is issued. It's a binder or commitment. It says that if you do all the things in Schedule 1, we will issue this insurance policy to you, subject only to the things we went over in Schedule 2, the exceptions. When the policy is issued, it looks similar to this, but it's only the second section. It'll have the names of the insured, it'll have the effective date that the documents have been recorded, it'll have the dollar amounts, it'll recite the fee simple, it'll then recite who title is vested in. Obviously, it's going to be the owner for the owner's policy. It's going to reflect that the owner is insured, the owner is vested in the owner for purposes of creating the mortgagee policy. And then all of these things that are here in Schedule B2, these exceptions from coverage, will appear as exceptions from coverage there, plus the real estate taxes. If you've properly resolved all the other requirements, the only thing you should have from the first page is number 2, the taxes and assessment. Everything else here should go away. Or maybe the submerged land, except if you get an affidavit or your personal knowledge that it's high and dry, you can take it out. Questions?
What about easement and abandonments?
Ask us. Give me more question.
do they have to record that in there as well, or like the previous, like, let's say you get an easement abandonment and then you get a title, do you have to record that there was ever even an easement before?
How are you gonna abandon an easement?
Well, I mean,
What are you gonna do? What,
you want me, okay, so an example, so I had a property and there's.
no, not why. What are you actually gonna do?
To build on it,
How are you going to abandon it?
through, like, all the documentation, I don't know, the
Okay,
legal
all right.
attorneys do it.
I'm trying to lead you, yeah, I know. So, all right, so
Lots of documents,
clouds of title,
yeah.
okay? Things are on title. So now we have an easement. And I've given Ryan an easement to come walk, let's say that these desks aren't here, that there's a separation right down here. But there's a blockade over there. And he wants the right to use that front door. So I give him an easement to come this way, to come right all the way through the center of the class to this point, and then go to that front door. I give him a written easement. Now, in the future, we're going to redevelop, and we're going to undo the blockade, and I'm actually going to have a road, a public road, or even a private road put back there, which means that he's going to have a much easier way to get out of the class. Okay? But in order for me to do my development and build my building, I have to make this easement go away. So the document is called a release of easement. As long as you have all the parties to any agreement that's recorded in the public records, with a few exceptions, but if you have all the parties that have an interest, in this case it's the holder of the easement, the guy that's got the right to use the easement, and the person who, really that's the only one who needs to release it, but I would normally do a two-party document with the owner of the land and the holder of the easement releasing this easement. The only time you would not have the right to do that by contract would be if the easement or other agreement was part of the zoning approval. I'm dealing with one right now on a building, and it is a declaration of non-concurrent parking restriction. I think it's something like that. And it's fairly simple, and I may have touched on this in one of the earlier classes. You have a restaurant that's in an office building. The restaurant is only going to operate in the evening. Obviously, the offices are primarily used during the day, so to some extent, the parking can be shared. So you don't need to have the number of spaces that would normally be required for both of these things to go on at the same time. So instead of having 100 spaces, they'll let you get away with 75 spaces, knowing that the two uses are not going to occur at the same time of day. I have another situation where it's a hotel and an office building together. Same thing. The guests are coming to stay at the hotel in the evening.
Same here with mine. I have a hotel, Airbnb, Publix, and apartment.
Right.
Same.
Okay.
One complex.
But the problem with that is there may be, that's not quite as clear cut
No, it's not.
of a separation of use. So but I'm getting aside from it. My concept is that was a zoning requirement in order to permit the restaurant to be put there. So in order to make it go away,
Where I live.
you have to go back to the city and say, hey, city, we've now provided enough other parking to operate this restaurant without that agreement. We want your authority to release it. That takes away one of the clouds of title. Other questions? Okay, we've obviously reached the zombie zone. I'm sorry to say that next week I am going to have to administer a test.
Let's go.
It's not going to be terrible. What I've been doing is I've been writing questions, at the end of each session. The question that I have, and I haven't quite resolved in my mind, is what part of the class to do it in. I hate. My first thought would be to do it towards the end so that you can finish and go. The problem is that I can see just from experience that by this time we're in the zombie zone.
Yeah.
So, if I do it first, then that means I'm only going to be taking material from the first 3 classes. which is probably the better way to do it. That's kind of what I'm thinking. I'm not trying to bust anybody's chops. I'm not here to make this a miserable experience. You know, if you all get all the questions right, I have no problem with that. You know, like I said, if you're paying attention, I did not go out of my way to make it particularly hard or tricky. And no, you can't write C for everything.
Damn.
It's multiple.
It's going to, right, the first one's going to be multiple, all multiple choice.
Really?
Still.
Don't say it
Yeah,
again.
exactly. Doesn't mean it's gonna be easy, but.
Will there be a study guide?
Like,
Yeah.
So, study guide.
It was multiple.
Yeah, I know, but I'm just saying.
Would you have any study
Hold on, guys, wait. Let's take some questions and let's talk, because I want everybody to have a fair shot at this. Go ahead.
So I was just saying, if you're gonna post this last year, next week, okay, so it's just like.
I'm going to try and post the slides. I'm going to, you know, it seems that I was successful posting the loan documents, right? Did I put the contract up or no? Oh, I gave you the contract.
Yeah,
I was able that, I did that because that was not so bad. I will do my very best to post the slides.
How many questions?